Welcome back to Classroom Insider Season 2. I am Professor Woody, and I am joined today by two more students who are going to talk a little bit more about the cases related to insider trading, or one case in particular today that has piqued their interest. So I'm going to go ahead and have them introduce themselves. I'm joined by Noah and Ahmed, so please say hey, you guys, and tell me a little bit about yourself before we jump in.
Hi, nice to meet you all. My name's Noah Gallagher. I am a 2L at Washington Lee University.
Hi, I'm Ahmed. I'm also a 2L at Washington Lee University.
Awesome. And they're in my insider trading class. And so that's why we get to hear from them today. So today, what we're going to talk about is a case that they have picked, and it is called the SEC versus OBIS, which is a very famous insider trading case, or at least a very important one. And I'm gonna have these guys explain a little bit about what's going on in the case, and then what I think stands out about this particular case. So whoever wants to jump in, go ahead and explain a little bit about what happened in this case. What is the background? What's set the stage here?
Sure. So the initial complaint was filed in 2002 or filed in 2006 regarding allegations from 2002. It's a civil case, not a criminal case. And so the SEC's version of events, it kind of goes as follows. We have this guy, Thomas Strickland, who is an underwriter and vice president at GE Capital. And through his work doing due diligence work, he obtained information about Allied Capital's pending acquisition of this company called SunSource. And according to the SEC, Strickland then tipped his friend from college named Peter Black about the pending acquisition. Uh, Peter went on to tip his boss, Nelson Obis, about said acquisition. Obis then made a call to the CEO of SunSource to let him know that he had heard this, he had been tipped, and we'll get more into this call later because we think it's kind of funny. But then following that, Obis's company, Winfield, purchased two large blocks of shares in SunSource. And, when this information became public, those shares almost doubled in value. And so the SEC brought this civil insider trading case, initially under both the classical theory of insider trading and the misappropriation theory.
Okay, and just as a quick reminder, what does that mean? What does that mean to have two different theories?
So initially, we had the classical theory of insider trading, which involves a corporate insider. That's the one that Justice Powell really wanted to stick with. There were seeds of misappropriation theory popping up in cases that he sat on, but he really tried to avoid it. And mainly involves a corporate insider. So someone taking corporate information, inside information and trading on it. And that could also apply, like here, this is a tipper tippee case. So where the corporate insider talks about the inside information with another person, the tippee, and then they trade on it. And then the misappropriation theory is kind of a catch-all where it catches people that are not corporate insiders and they misappropriate confidential information. And then either they trade on it or it could be another tipper tippee situation where they tipped that material, non-public information to a relative, a friend, someone they know, and then they trade on it.
Okay, got it. But sort of base misappropriation has to do with trading based on inside information, but potentially learn from someone who's not the insider, or you're basically breaching some potential duty to whoever you learn the information from, even if there might not necessarily be related. Or I guess I should say, you might not have to end up trading in the company in which they are the insider. Okay, okay. All right. So you can see how maybe this set of facts, as Noah was explaining them, could give rise to maybe one or the other of these theories. Okay, so the SEC, you say, brings a case essentially based on both. So tell me what happens here then when they get into court.
Sure. So the SEC goes to court and they're seeking disgorgement of about $1.3 million in profits they think are unfairly earned. They're seeking civil monetary penalties. They're seeking restrictions on these folks being officers or directors in companies that trade securities. And as I mentioned, the SEC is basing its theory of liability on both this classical theory and this misappropriation theory. And they get to court, and the district court grants summary judgment for the defendants. Um, District court throws out the classical theory, essentially concluding that these guys weren't really insiders of the company. The SEC had been bringing it under this idea that they were temporary insiders and they assumed a duty to the company. But the court doesn't see it. The court says there's no legal or fiduciary duty. There wasn't even a confidentiality agreement between GE Capital and SunSource. So there wasn't, the court couldn't find a duty, and it throws out the classical theory on that ground. And it also throws out the misappropriation theory on the basis that they didn't provide sufficient information that Thomas Strickland, the guy who had the information, had breached a duty to his own employer and couldn't find deceptive conduct on that ground. And so SEC throws it out and we get an appeal from there. Or sorry, the district court throws it out and then the SEC appeals.
Okay. All right. So interesting theory. And I think you can see how this is probably a pretty close case. So what happens then on appeal?
So the case goes on appeal, and then on appeal, the Second Circuit says that on the misappropriation theory, so they don't address the classical theory. I think the SEC in their appeal only moves forward with the misappropriation theory. So they say on the misappropriation theory, there could be liability. They remand it for a trial. And the interesting thing about the trial, when it goes to trial, OBIS actually wins. 2014, there's a trial and OBIS wins. And then Gibson Dunn, that's the firm that's representing OBIS, they put out a publication, a whole case study. They title it a case study on taking the government to trial and winning. And then they talk about all the record keeping that they did, all the ways that they, basically won the trial. And they were kind of dunking on the SEC. And they were like, the SEC brings these cases thinking that they'll always get summary judgment, but let's actually take them to trial and let's actually win, which is really interesting. But back to the appeal, they say that there is a fiduciary duty. I think there was something about GE Capital maintaining a record of companies that they were doing due diligence on that was in the sphere of confidential information, and some sources never made it in there, but there were a lot of hints around Strickland knowing that this was confidential information. And a couple interesting things that come out of this case. For scienter, they say that recklessness, at least for the Second Circuit, could qualify where there's extreme regard for the truth, which was interesting because they also say that the Supreme Court never had the opportunity to address that question. And they also, I think they denied a cert that would have pivoted on that question, but they say at least for the Second Circuit, recklessness would qualify. And the other big thing that comes out of this, which, the Second Circuit has kind of been dealing with for a long time, is the personal benefit thing.
That's an interesting angle here about what, if anything, is the personal benefit, especially since they dropped the classical sort of tipper to be challenge. So this was under misappropriation, but I think you're right in trying to sort through where does scienter fall in this. You're right that recklessness was a bit of and still maybe to some extent is a bit of an open question. And Justice Powell versus Hochfelder describes why we need, like, more scienter is required for 10b-5, but leaves open in a footnote sort of this, we're not going to address where recklessness falls. They say definitely not negligence. We definitely need something closer to scienter. And then the gray area maybe between the two, we're not going to really speak to on that particular case, which was one of the older cases that really was, I think, the defining mark of saying scienter has to be found if you're going to bring anything under 10b-5. So that is, I think, that's why I think OBIS certainly, definitely caught a lot of eyeballs, a lot of sort of people thinking, oh, this is definitely a new interesting case because it's addressing that, what seemed like that open question of the level of intent you need to show here. So what about the personal benefit, though, did you find was interesting here?
So with the personal benefit, the main thing that comes out of this case is when they're talking about at least tippy liability, they say that there's 4 things that you need to show: that they knew that the inside or the tipper tipped, second, material non-public information. Um, and I forgot what the third one was, but the first one is they have to show personal benefit, that there's a personal benefit accruing to the tipper. But the interesting thing about this case is the court says that the tippee, and they do it really secretly because the first reading of the case, I didn't catch it until I was doing more research into this case. And I was like, oh, this is the big thing for this case. They say that tippies don't need to know that the personal or the scienter requirement doesn't apply to personal benefit. So when it comes to fee liability, tippies don't need to know that the tipper was getting a personal benefit from this. And that became a huge thing because there were so many firms when they do blog posts. I mean, even Gibson Dunn in their article on taking the SEC or on taking the government to trial and winning, they said that's a huge development because that extends, especially in cases like these where there's a tipping chain where it goes from Strickland to Black to OBIS, where there's a whole chain. If we keep developing that chain, then you have remote tippies who might not know that there's a personal benefit accruing to the tipper, but who would still be brought to court and litigated against, and they might find themselves liable for insider trading, even though they don't know that the personal benefit accrued to, or there's a risk of a personal benefit accruing to the tipper. And at the time, the big thing was like, okay, Newman's on appeal. We're going to find out what the court says in Newman. And in Newman, which was a case based on the classical theory, not on misappropriation, they said that you would need knowledge that scienter would apply to personal benefit. But we're still left with OBIS seemingly being good law and seemingly still being on the books. And it's just building up the Second Circuit's jurisprudence on personal benefit, which is just getting so messy. So now we're thinking maybe because this is a misappropriation case, and misappropriation, you don't need to show scienter. That applies to the personal benefit. But Newman, they said that you would need to meet the scienter requirement for personal benefit. And that's a classical insider trading case. So are we thinking if another case like OBIS comes on, do we still not need to show knowledge of personal benefit or TP liability? That's the interesting thing about it.
Yeah, and I think
Yeah,
it's
definitely. Go ahead, Noah.
very much an open question which scenarios this applies to, whether it only applies to misappropriation, whether it applies to classical as well, whether it only applies to civil cases or can be extended to criminal liability. It really opens a lot of doors and leaves a lot of unanswered questions. Also noticed that you discussed this in your footnote 83 of one of your articles. We did find that. It's kind of funny.
That's a good catch, buried way at the back when I discussed OBIS in that article. No, I think you're right that the big issue here is that this, like a number of other cases that we've seen in misappropriation theory or under that theory, including shadow trading, which I'm sure we will talk about in this season of Classroom Insiders as well. There is this push that is allowed almost under misappropriation theory. There's a lot more flexibility. And I think what's interesting, I think, teed up there, Ahmed, is if you laid like side by side the facts of OBIS and Newman, the fact that Newman was a tipper-tippee case, that you need to show all this personal benefit and knowledge that the tippee knew that the tipper had received that benefit. All of that is required in order to prove the breach under classical theory. But OBIS was sort of loosening that for a misappropriation theory case, which is a little wild. And so you even, I think, point that out. That like, how interesting does this look when, depending upon what theory, and really then who you owe the duty to will decide how much you need to prove and how easy it is to prove insider trading. I think that is a really interesting wrinkle that OBIS sets up for us.
And it would be very odd to have laxer standards, in my opinion, for misappropriation theory, because the duty is so much farther removed from the company whose stock is being traded in. I mean, to say that you'd have less of a duty to your own company than to another company is a very strange scenario to end up in.
Yeah, I see what you're saying there. Yeah, so what other thoughts? Are there any other thoughts you have about this case and or how this is lined up with a number of the other cases we have read or talked about in class? The cases, for the most part, we read and talked about in class were all featured in season 1 of this podcast. So I would recommend listeners go back and listen to a number of those episodes. Particularly, we had one on Newman, if to refresh any recollections. But how do you feel about where this particular case lands, or do you just have any other thoughts about this one?
I
Yeah.
think this is a case. Oh, sorry.
Oh, you go.
Where you can tell how excellent the lawyering was over a decade, 12 or 13 years. It was a quite drawn out case. It may be the longest running insider trading case, and they have done an excellent job here. Also interesting that the SEC brought it almost at the end of their statute of limitations period. This happens in 2002, and they wait until 2006, and then redrafted in 2007. So they're running the
Mm,
clock on their end as well.
Yeah. I also think, I mean, the big thing with this case is the personal benefit thing. That's the thing that the Second Circuit has been struggling with for so long. And this might make sense, but there's a group of attorneys on LinkedIn who kind of treat it like Reddit. And every week, there's this one person who talks about the blue book, which is insane. But one of the things last week they were talking about was how I don't remember the name of the case, but Justice Thomas, of course, it's Justice Thomas, uses a parenthetical that just says cleaned up. And he's trying to summarize the law and he's cleaned up. And everyone's freaking out on LinkedIn. I don't know why, but they're like, this isn't in the blue book. Maybe it should make its way into the 22nd version or the 22nd edition of the blue book, because that is the case. Courts will say something like 40 years ago and then we'll keep quoting it and we'll keep putting in ellipses and we'll keep trying to modify it when it's
yeah.
you just need someone to clean up the law now. And I think that's the big thing with the personal benefit test coming out of Dirks. I mean, Dirks was also an interesting case because not only was it Justice Powell trying to limit liability for insider trading, but also it was a whistleblowing case. And it was, we were trying to protect someone who kind of did the right thing. And we see that split. UPenn's Journal of Law and Economics kind of had an article a couple of years ago that was talking about the personal benefit test. And they said that the NCC would rather have it be, complete liability for anything and everything, abstain or disclose or abstain, no matter the circumstances. And the Supreme Court has generally tried to make it go, no, not liability for everything, but, liability for certain things which they want to him on fiduciary duty. And then they kind of implicitly make this connection that where there's a personal benefit sort of to the tipper or any person trading using inside information, then there's just an automatic breach of fiduciary duty.
Mm,
But that article points out that even if there's two problems with that. First is what if you're just like sitting on a bus or a train and you just like you're loudly talking about it and everyone around you can hear it and they go and trade on it, but there's no personal benefit, so you're not liable. But
right.
with that is you've still breached a duty. You've still breached a fiduciary duty of at least care in handling that information. So liability should attach. And the other one is where there's intentional, and I'm having a hard time coming up with a hypothetical, but maybe where there's like intentional tipping, but there's still no showing of a personal benefit and the tipper still goes scot free and the tippy as well. But even then you've breached a fiduciary duty, you've divulged confidential information, so you should still be liable. But then we have cases like Dirks where you want to protect the whistleblower. So I think we just need a fresh inquiry into what was the reason that this information got out. And if it
Yeah.
was a reason that was, good enough, like whistleblowing, maybe we dismiss the case. And if it actually shows that there is trading that we're not okay with, then we proceed. I don't really think the personal benefit test is doing anything except causing confusion. We just need to clean up the law.
Yeah,
Yeah, no, that's fair.
moving it all together. But that's
Yeah, it's a tricky space to be in. I think you're right. I think misappropriation's attempt to handle it without a personal benefit attached, just some breach of duty. Although, as we have discussed, personal benefit is supposed to be evidence of the breach of duty. It's just we're sort of stuck with it in some ways, but I think yeah, depending on how narrowly or broadly we read it, there's some significantly different outcomes, which doesn't sit well with us when we're trying to think about what is predictable in the law, what is prohibited behavior. Does feel a little bit like after the slew of cases and OBIS included, it's sometimes hard to know what case will end up with liability and what cases might not. So we still are in that same place to some extent with insider trading. But I really appreciate you guys educating me and our listeners about this case, especially since it's one that we didn't read for class. You did your own research, and that was really impressive. Appreciate you telling us all about it. Unless you guys have other thoughts or comments, I just want to thank you for being part of this and thank you for your time. And if there are no other comments, then we will see you guys next week.
Thank you so much for your time, Professor Woody. It was a pleasure doing this with you.
Yeah. Thank you so much. And can't wait to see you. Do we have
Next week.
we
All right. Awesome. Hold on.